This is The Law School Show. Discovering the person behind the resume. Bringing you their stories and their tips on how to succeed in your legal career. Catch it all here, right now, on The Law School Show.
Good day, viewers. Welcome to The Law School Show. My name is Amos Vang, and I will be your host for this episode. My guest for today is Roy Sengupta, law clerk in the litigation department at the New York office of Debevoise and Plimpton. In 2016, Roy graduated with high distinction from Carleton University with a Bachelor of Humanities. In 2019, Roy graduated cum laude from Harvard Law School. During his time at Harvard Law School, Roy was an article editor for the Harvard International Law Journal and acted as a mediator with the Harvard Mediation Program. In only his early 20s, Roy has published extensively on the field of sustainable development and infrastructure, including as primary author of a chapter in the book Designing a Sustainable Financial System, Development Goals, and Socio-Ecological Responsibility. Roy has also served as a research assistant for Professors Maya Steinitz and James Saltzman. For Professor Steinitz, Roy assisted with the research and preparation of legislative testimony regarding third-party litigation financing legislation in the New York Senate. For Professor Saltzman, Roy assisted in the editing of a textbook on international environmental law. Harvard-trained, knowledgeable in the world of international law, Roy is my guest for today. Roy, thank you so much for coming on to the show.
Thank you for having me.
So let's go back to the very beginning, which isn't that long ago, just a few years ago. When did you first want to go to law school? And what inspired you to go pursue the legal profession?
What inspired me to go to law school? Well, I guess that I certainly, when I started out in Carleton University, I've been very active in politics for a long time, and I suppose that was sort of my initial inclination, was that I would become like sort of a political staffer or something along those lines. And I kind of transitioned to law and the legislative process, but I think that with the interest in politics, I always sort of had that interest in the sort of legislative process, lawmaking, that sort of thing. And when I sort of went into Carleton University, I sort of came to I sort of joined the Law Society there. Undergraduate mooting, actually, I think had a big role in sort of like influencing me to sort of say, law could really be for me. Undergraduate mooting, if you don't know, is basically a mock appellate case, basically, and so as a mock appellate case, you basically pretend to argue it. You have two sides, and you pretend to argue the appellant or respondent, and that sort of argumentation, I found that I very much enjoyed, and that was, I think, a big influence for me in terms of going to law school, and I think as well, but more broadly, it was, I think, a stock taking of sort of the skills I had, the things that I enjoyed. I enjoyed public speaking. I enjoyed writing. I enjoyed, research. Actually, I did enjoy research. I always enjoyed research in terms of like researching my essays and what have you, and the detail and nuance of these sorts of things. And I felt that law was sort of a career that allowed me to use those skills. And so that, I think, is the broader reason why I think I decided to go to law school.
And you mentioned undergraduate mooting with Carleton University. Me being one of your former teammates, yes. All those years ago, 5 years ago, let me tell you, dear listeners and dear viewers, that Carleton's moot team is a team that is quite feared amongst undergraduate level mooting teams. We've got not just the sheer numbers, but also the sheer talent as well. I mean, I remember back when you were still mooting at Carleton, you had quite a number of quarterfinals and semifinal performances against a competition of about, I think, almost 200 teams or something like that. I could be exaggerate. I could be getting my numbers a bit off on that, but
Mhm.
it was
Mhm.
some crazy high number of teams.
yes.
But you were regularly hitting
Mhm.
the quarterfinals and semifinals, and I had the pleasure of practicing with you
Mhm.
back in my first year undergrad at Carleton. So yeah, so Carleton's moot team is certainly a strong moot team.
Yes.
And how did you make such consistently strong performances at these moot competitions? How did you perform such strongly at
Mhm.
Carleton's Capital Cup and at the Osgood Cup?
I mean, we've because pretty consistently had a lot of quarterfinal performances. I know me and my team were always a little bit frustrated that we never were able to really push through and really take home any of the competitions. But we did actually get some speaker awards as well, and so that was a nice little prize as well, that we were sometimes able to finish in the top 10 of speakers, and we got a nice plaque for that. But certainly, we were, I think, very consistently. I think even if we were not specialists in those final rounds, I think in those final rounds we often sort of like narrowly kind of like had decisions go against us. But I think so in the preliminary rounds on the first day, I think you're right. I think we really were able to sort of get it down how you, and that's a huge challenge. You're right. You're talking about in that 200 team round, how do you get to the final 16, final 8 teams that actually makes it to that knockout stage? And I think that we certainly did gain a mastery of how to do that. And I think it was really, I think a combination of I think really sort of planning out the argument. I think really bringing something to the table in terms of the argument. I think that when you're talking about distinguishing yourself and in those competitions as well, it's about the judges giving you a high enough score on average that you got the average score needed to make it through to the competitive rounds. And so you could have a very good performance. You could be, let's say, number 30 of 200 teams, and you wouldn't be making it to the next day. And so, that was something that we always bore in mind, was that there had to be really an extra step there in order to get to that knockout stage. And for us, I think that extra step often was ensuring that we brought something to the table in terms of what our advocacy was presenting, in terms of like novel argumentation. If you just run through the standard argumentation well, you may get to number 30 of 200 teams, but you may not make it to the knockout stages. You have to have something that I really think really sticks out in the judge's mind enough that they feel willing to really give a very high score, because it has to be more than just a high score. It has to be a very high score to get to the next round. And so it is a chancy thing. It is a challenging thing. And so I think you're absolutely right. I think we were very fortunate, and I think to be able to. And we had a lot of Carleton teams as well, just sort of figured out the formula for getting to the knockout rounds each and every time. And, but it's a very chancy thing. But it really sort of comes down to you and your teammates sort of really have to think about what is it special that we're bringing to the table, because just doing the normal argumentation, the obvious arguments, and doing that well won't be enough to get you to the competitive round. You've got to take some risks with it. And I think that's what me and my teammate always did, was calculated risks we took in how we argued things. And we did that competently. We did that in an organized fashion in terms of understanding who took what argument, how is it going to be broken down, and I think as well, answering the judge's questions is key as well, like taking the risk on the argument and then answering the questions that you will inevitably get on that risky argument, answering them competently and well. And that means answering the questions directly, which I think is something that a lot of people miss. I mean, if you really just try and spin it, you won't necessarily always get the top scores. But if you really answer the questions directly, you really grapple with a challenging argument, then I think you'll stick out enough to hopefully make it to the competitive round, the knockout rounds.
And what sticks out to me is that most of our teammates on the Carleton team, most of us all went to law school or are in law school.
Yes.
So
absolutely.
either in Canada, the US, or
Yes.
the UK.
Yes.
So that's saying a lot about just the talent pool that we had back then.
Absolutely.
And I would assume that it's still a similar level of talent nowadays with Carleton. I mean, it's been a long time since I've stepped foot in Carleton, and also a long time since you stepped foot in Carleton as well. But it's a testament to just how competitive the whole competition can be, even at the undergraduate level, let alone at the law school level.
Absolutely.
I mean, I'm not sure if you had any mooting experiences maybe at Harvard that you may have had that compare to the Carleton experience.
You know, the funny thing is that mooting is a bit more of a Canadian thing, I've actually found, than it was not as prevalent at Harvard. There was certainly things that were similar to mooting. We did do, you had the Ames competition, for instance, which was an in-house and we didn't make the knockout rounds in that, me and my teammate, but that was an in-house competition. And so you only compete against other Harvard students. And so this kind of intercollegiate mooting that we sort of saw in Canada, and that you do see at the law school level in Canada a lot, and that's something people should be clear about. If you're going to Canadian law school, there's a ton of this. And there's often also far more creative moods than you'll find in undergrad. In undergrad, you have the really standardized, arguing an appellate case mood, and that's pretty much what's available in terms of undergraduate. I think it's a great introduction. I think it's really all you need in undergraduate. But I think that once you hit law school, you learn about all kinds of other aspects of law. So you have a land stand like negotiations and more case type competitions, but a really much more creative moods than you may necessarily get in your undergraduate, you'll get in Canadian law school, and a much wider diversity of things. And so that will play to the strengths of an individual person much better. But in America, there is something called mock trial, which is much less prevalent in Canada than it is there. That is a trial level mooting. I did something akin to that with a trial advocacy workshop at Harvard Law School, which was just fantastic, actually, and really, in terms of like honing your trial level skills. And trial and appellate are, of course, vastly different practices in terms of the need to establish a fact record at trial and what have you. Whereas in appellate work, at the end of the day, you're dealing with an established fact record. And so mock trial is more prevalent there, particularly at the undergraduate level. They do mock trial rather than mooting. And as you get into law school, it is less prevalent. And I think there's a few reasons for that. I mean, Ames is, of course, a spectacular competition, and Harvard Law School being as large a law school as it is, you do get really high quality advocacy. I remember we'd watch, actually, Ames competitions when we trained, because there is a very high standard of advocacy there. But that being said, that kind of intercollegiate mooting is not as present there. There is some, but it's much smaller. In fact, actually, in the international arbitration sphere, you have this in Canada too. In the international arbitration sphere, there's more participation by American law schools like WTO moots, investment arbitration, what have you. In terms of domestic mooting, it's less, I'd say. There is some mock trial still at the law school level, but small numbers of people. And I think part of the reason for that is, I think, the sheer number of law schools involved in the US makes it organizationally, I think, close to impossible to really organize events like that, because you have like 200 law schools in the country there. And I guess it never really occurred to people to do it state by state, because there's a lot of differences between the law schools and their embassies as well. And so it's harder to really organize those kinds of intercollegiate experiences, which I think is more prevalent in Canada, generally speaking. Like beyond just mooting, just the general intercollegiate experience between law schools in Canada, particularly within provinces. So particularly within the province of Ontario, let's say, is much more prevalent. I mean, Harvard Law School did have relationships with other law schools, absolutely, particularly with the Yale Law School, because they are quite close by. We'd have a basketball game every year with them, what have you. but that kind of collegiality is less in America because the legal profession, is a bit more stratified there at times. It's and the diversity of law schools just makes it a challenge, I think. And so I think that's a big part of the reason why the main mooting at Harvard is a within the school competition, and that you don't have as much intercollegiate competition as you would in Canada.
That's actually very, very interesting. I never would have thought that the U.S. didn't have as much of an intercollegiate mooting culture as the Canadians do. You were mentioning arbitration moots. To me, one of the first moots that comes to mind is the Vis moot, of course,
Right.
which is the moot that Ottawa has done quite well, and I think we've won twice or three times.
Right.
Probably the only law school in the world that has won that many times. I could be wrong, but people might want to verify that. But it's still quite impressive to win it even once, let alone more than once. But yeah, the intercollegiate part, the lack of the culture in the U.S. surprises me quite a lot, especially given that you would expect from the number of law schools there that they would have some more structuralized form of bracket system, similar to how they would have treated the NCAA Div 1 or Div 2 or something like that, right? So that's actually quite interesting. And
it's actually an idea that you raise, and I think that's a big part of the problem is how would you structure a competition like that domestically in the US? I think, of course, there's this traditional distinction of the T14 law schools in the US, and that would make the most sense probably in terms of a comparable intercollegiate competition to what you're seeing in Canada, particularly in the province of Ontario, but even in Canada generally, where you're having, let's say, max like 20 schools or so. And so 14 schools would be a good starting point in that regard. It is a point of curiosity for me why that hasn't happened yet. Even if you don't necessarily want to compete with all 200 law schools in the US, why we wouldn't necessarily compete with the T14. I think there's a big part of that is just probably some of the controversy it might cause, the idea of these exclusive competitions, the idea that T14 is not an official distinction. And I think that would probably be the issue with sort of like an NCAA type format, which when you mention it at first glance makes good sense given the structure of things there, but nonetheless would represent a formalization of a system which is not actually a formal system. And it is simply a system that law students recognize, that law schools, in fact, recognize. If you're talking about how the administration of law schools reacts to each other, see with OCIs, for instance, or what have you, the T14 takes its marker, or like the grading changes that happened during coronavirus. The T14 takes its mark from other T14 schools. It's not necessarily going to take its mark from schools outside the T14, because frankly, the priorities and types of jobs they're looking at are often quite different. That's not to say you can't get big work from T14 schools, you certainly can, but talk about the majority of students, it's going to look different. And so for that reason, even though it pretty much isn't institutionalized, the distinction, there is, I think, a concern about formalizing the distinction, which I think has absolutely restricted intercollegiate interaction of all kinds, not just mooting, really also more collaborative interactions as well. And I think that as well with the Vis mooting and what have you, absolutely, there's a presence at Harvard there as well, and Harvard has had some good performances there too. And but I think it is less prevalent for sure than at a school like Ottawa. It is less prevalent.
And one thing that I also realized about the Canadian law school culture versus the American law school culture is the issue of rankings. In the US, it's a huge, huge deal. As you said, the T14 isn't exactly a formal designation, but people treat it as if it is
Yes.
a formal designation.
At all levels, yeah.
And the rankings are huge. Some of it is arbitrary, but a
Mhm.
lot of it is surprisingly useful for determining whether you're employable, not only in terms of just what law firms or legal organizations are looking at your resume or your transcripts, but just by the fact of the resources that each of those law schools are given. For example, you went to Harvard, you have some of the best resources in the country. Whereas if you went to a much lower ranking law school, chances are you won't have as good of a resource in terms of teaching, research, or just the practical or learning skills that you would have had at a higher T14 or even an Ivy League law
Right.
school. And that's something that really struck to me, because here in Canada,
You
yeah,
don't
we
have-
have the Maclean's rankings, but
Yeah.
nobody really cares about that.
And those
right?
haven't been released in some time as well.
Exactly. Here in Canada, it's we all say that there are good law schools and there are great law schools, but the difference is so small. It's not even calculable. As long as you
Right.
come from a law school here in Canada, you're
Mhm.
pretty much employable. Well, not automatically, but it's not like you're going to be, oh, you go to a terrible law school. Yeah, I'm not picking your resume up anytime soon.
Yeah.
And
Well, there's
that's
some controversy in Canada too with the expansion of law schools as well, and you know, some law schools, such as, for example, you know, the opening of Ryerson Law School. And I mean, certainly for some people, there was an argument being made that you risked, with having 3 law schools in Toronto, Osgoode, U of T, and now Ryerson, that you risked creating that kind of American system because you were oversaturating a particular market with multiple law schools. And that is actually, there's some validity to that concern regarding the risk, because that is part of the thing you see in the US. A city like Boston, a city like New York, a city like Atlanta, Houston, wherever kind of thing, Los Angeles, San Francisco, you know, you have huge amounts of law schools in those cities. We're talking 5, 6 in a major city at least. You could have 7, 8 in a major city. Talking about New York City, God knows. I mean, it depends on how far you want to count it, but how far you want to go into the outer boroughs or the suburbs. But there's a huge amount of law schools in New York City, and so, you know, I think the Canadian system has a regional system, which I think is being undermined to some extent now in Ontario with the opening of so many law schools. But I think that traditionally it's been a regional system, whereby you have one, Toronto being the exception because it is such a large city, it has 2. But generally speaking, you have 1 law school per city. You have, or Montreal also kind of being a exception, but you guys have the French law school and McGill, the English law school. But generally, you have 1 law school per city, and you have only a few law schools per province. And so there's a variety of reasons why I think it hasn't come into the same effect in Canada. I think that, I think that certainly with the American ranking system, it's not necessarily, I'd say that that there certainly is a resource difference. I wouldn't necessarily say that simply because people go to low-rank schools, they're under-resourced, education per se. I think that, in fact, you know, certainly in low-ranked law schools, in some respects, you know, I've seen very good educational standards at those schools. But at the end of the day, it is the job outcome that I think drives the rankings by far the most. It is this idea of, by and large, and again, this is not to say it's 100% true, because there are absolute students from outside the T14 who do go into it, but it's much harder for them to do so. And, you know, it is certainly a situation whereby, you know, the majority of students at a T14 are looking at a big law job, and the majority of students that are non-T14 tend not to be, particularly the lower down you go. And that, I think, is really, you know, driven at the end of the day probably by, you know, clients of law firms, clients of the large. At the end of the day, they're going to be driven by their clients and what their clients want and feel like they need from the attorneys in particular firm. And, I think it's certainly the case that, when you're talking about a system that has 200 different law schools that are in some cases privately owned or part of privately owned institutions, which is a big difference with Canada, because Canada, these are all publicly owned institutions which are regulated by the ministry, which is a lot harder to do in the US, not to mention we have 50 states in the US. God knows what each of their ministries are doing. You have private institutions that are frankly loosely regulated by the ministry. And there's a feeling that you can't always trust every institution and the educational program that it's providing, as well as the fact that in Canada, you haven't had these law schools that really cater to the lowest end of the statistical range. Again, a concern with the expansion of law schools in Canada has been that you will start to get these schools. And again, there's an argument to be made that Canada is changing to some extent the system. But traditionally, you have not had that systematic undercutting of standards by certain law schools in Canada. And I think still you do not deliberately have that. But I think in the US, you probably deliberately have that with some schools. And, and so I think that's a big thing is that you had law schools where, frankly, you can't hire from some law schools because they don't pass the bar exam. That's the bottom. If you can't get a lawyer who passes the bar exam, you don't really have anything in terms of, because that person cannot enter the profession. And the bar exam is the barrier because, of course, as we might get into later, we don't have articles in the US. And so if you're talking about a school, and we've had schools in the US at the very bottom of the rankings, and this is part of the problem. It's not the entire problem, because there's many low-end law schools, again, that do have good bar passage rates, but at the bottom of the rankings, you've had law schools that have like 30, 40% of their people passing the bar, or like less than half their people passing the bar. So if you hire someone from that school, chances are they won't pass the bar on their first go. And that's really no good for most employees. And so, that is because they were undercutting the standards, admissions-wise, probably. And but I think as well, there's certainly a lot of vectors to this sort of analysis of the US system. And it's something that I've thought about quite a bit, being part of the law school and what have you. At the end of the day, there were well-meaning intentions behind some of the undercutting of the standards that did take place. I think it had a bad outcome in the end. I think it was negative, but the intention that some people have, and I choose to believe that many people were distinguished educators who genuinely believed that they were opening the legal profession to individuals who had not had access to it before, and to individuals for reasons of social class, for reasons of historic discrimination because of race and what have you, did not have that access. And the question is, how best do we serve those people and give them access to the profession? Is the T14 really serving them that well? Probably not. And so there are people who, had potential, but who had issues in terms of, prior educational experience, being able to write the LSAT, being able to access the materials to write the LSAT, having the time to write the LSAT, having the time to get a good GPA, having the materials to get a good GPA at their college. And so, those are challenging issues. The solution, I think, was never to set them up in such a way that you put them into debt, $200,000 American in debt, and then they don't pass the bar exam and they don't have access to a job. You've not done them any favors doing that. You've just made their position far worse. And so certainly there's a sort of grifting that can come from that, because they perceive, and particularly underprivileged communities, they perceive the professions as, a path out of sort of the struggles that they may be facing. And then to take that and then promise something that wasn't delivered was not a good thing, I think. But, I think by the same token, I think particularly, and this is part of the challenge I think law schools face now. I think particularly some of the issues that we're having is, I think, for instance, when I think back to my time at Harvard Law School, and this is something that I spoke about consistently, was the idea when I did some stuff on student government with regards to, at the end of the day, is there a degree of racial diversity at Harvard Law School? I think there is now. I think there is a degree of racial diversity. It can always be improved, but I don't think necessarily that we're, a white school. But I think that when it comes to social class, it remains the issue, I think. And, you can have good racial diversity, but still not be open to people of lower social classes. And I think that continues to be the case at places across the T that, and particularly in the Ivy League, but across the T is how do you create accessibility for people from lower social status and who may have had tougher life experiences to really come to these sorts of schools. And that's not to say there's not efforts in place, but the fact of the matter is that the measurements that you engage in, and that's part of the reason why the GRE is now allowed at Harvard. But the part of the reason that the measurements you engage in, the LSAT, the GPA, and I'm not saying that we should do away with those entirely. I think they're important. I think that we see with the bar exam results that they are important, and we have an obligation to ensure that, we're not making false promises to people that simply because you come to X and Y law school or get X and Y law degree, that's going to necessarily transform your life if it's not. But, I think by the same token, it is certainly, I knew very few people who, they say that, and I'm misquoting this, but there was a statistic out that said something like 80% of Harvard Law School's population came from the top 20% of the income brackets, the income bracket in America, basically. And so for that, and so I think it's a very difficult issue because I think that you have to select somehow, to get how to get into these schools. But I think that you also, have to, and affirmative action, I think, has had positive impacts in terms of increasing racial diversity. But I think that how do we start accounting for social class and life experiences in those vectors? It's a harder question. And I think that, it's certainly something that we have to grapple with, particularly as, we come to realize that these low-ranked schools in America have not fulfilled their function or their promises in the way that we would hope.
One thing that will not change for the foreseeable future, if ever, will be the competition to get into law school, whether you're going to Canada, the US, or the UK.
Mm-hmm.
And that kind of competition is going to be extremely fierce, regardless of the year that you apply, regardless of the generation that you apply.
Mm-hmm.
And a lot of this competition is also determined by as you said, the life experiences that you've had. And from what I've understood, Roy, you yourself have had a lot of experiences as well, not just in terms of mooting and legal advocacy, but also in another factor, which was model parliament back at Carleton.
Mm-hmm.
You were involved for about 2 years or so in model parliament. For our audience members that don't know what it is, could you explain to them what is model parliament and what you exactly do in model parliament?
Sure. Model parliament is basically a mock-up of sort of our governmental institution. Basically, we form make-believe parties, and then we sit in parliament and we try to legislate, basically. And so it really is a very interesting and unique experience because you can form a party based on whatever ideology you like, and you can then go into parliament and try and pursue your agenda and discover how through parliamentary mechanisms parties' agendas can succeed or fail based on the usage of parliamentary mechanisms and the need to keep your own party together, to gain support from opposing parties who have different agendas, to create compromises. And I think so in that sense it was a very positive, I think, view of what Parliament could be. And we saw the negatives as well, but I think we saw also the positives of how, through working in model Parliament, we tried to create compromise. We tried to create agendas that could pass with broad consensus. And so I think that it really, you go through all the aspects of sort of parliamentary procedure in model Parliament, based with a party that, you've sort of created yourself, or one that you've joined from one of your friends or what have you.
And with your experience in model parliament, combined with your student government experience at Carleton as well, this provides for essentially a trial by fire when it comes to advocacy, public advocacy.
Right, yes, yeah.
So
right.
how did that trial by fire prepare you for Harvard?
I think it's one of the main ways that it prepared me was, I think, in terms of the Socratic method, in terms of the idea of people calling on you for questions during class, and being able to quickly come up with a response and come up with a strong response to that. I think as well, it also, I think, drove my interest in what aspects of the legal profession I wanted to pursue, like going into a more litigation-oriented path as opposed to a transactional-oriented path, which for big law is one of the big choices you have to make is litigation and transactional. And certainly, it was, and I think certainly a big factor in why I chose to go into litigation. I think also just really, I think, as I said earlier, my finding that I enjoyed those things was, I think, a big factor in my choosing to go to law school. And I think just it really had impacts, like just across the board, but sometimes more intangible than maybe I can describe. But I think really in terms of your ability to articulate a point, discuss things, and what have you, it is really amplified, and the ability, I think, as well to withstand pressure, to withstand working relationships with people, I think actually can really be helped by stuff like student government, model parliament, and certainly a lot of the interpersonal skills that I learned were particularly not so much model parliament, but from student government. I'd say I learned a lot of interpersonal skills, and those have served me well, both in school and in working life.
And those are important experiences as you were considering where you wanted to go to law school. You were considering, if I remember correctly from our personal conversations 5 years ago, you were deciding between Canada, the US, and the UK.
Yes.
What attracted you to these three countries, and why did you choose Harvard as your final choice?
Well, I was born in London, and so a British citizen as well as a Canadian citizen, and so the UK was obviously, I think, an option, and it's always been an option. I think the UK I stopped considering relatively quickly because just of the differences in the system, basically, the fact that I'd already done an undergraduate degree, like integrating back into that system, I think would have been more challenging than it needed to be for me. I think there's very good opportunities in the UK. Certainly, Oxford now, I believe, has a standardized test, if I remember correctly, the LNAT, which is sort of like a better version of the LSAT, probably because it's more writing oriented, what have you. But I didn't want to do another standardized test. The process was a little bit more complicated for me coming from North America to really go back to that system. And so I think I relatively quickly discarded that option. And so it really came down to Canada and the US, and which both had systems that I was familiar with and could easily integrate into. And it was, I think, in Canada, and yeah, really, I was really debating between Canada and the US. And I think the factors that went into that decision were sort of, I think really I had an interest in international law, and I think that was the tiebreaker, I think, in terms of taking me to the United States, was sort of, I felt that Harvard Law School would give me more opportunities, particularly for international commercial practice. Which is essentially what international arbitration is and what have you. And international, we have international white collar as well and what have you. And so, but really it's international commercial practice, international business practice, which is what I had grown familiar with at Carleton. as you know from my publications, I'd go with sustainable, but at the end of the day, international commercial practice, and doing that in a way that, you know, withstands crises like coronavirus, for instance. But, you know, having worked with, you know, oil and gas mining companies and seen sort of the considerations they had in this evolving world that we have, and you know, whether it be, you know, the impact that global markets have on those commodities, whether it be, you know, how they manage investments in you know, foreign countries, and the kinds of provisions they have to put in place to do that, and the kinds of considerations they have to put in place before they invest in a foreign country. And as well, you know, I think that just having an interest in that sort of practice, I think led me to the United States, in part because I felt there was more opportunities at US law firms to have that kind of practice. And, you know, not just internationally, but even domestically as well, like domestic commercial disputes as well, which are an important foundation for international commercial disputes. But, you know, I sort of felt that, you know, having that international law interest and what have you basically was I think really what pushed me to the United States over Canada. And so, and yeah, I think as well, other considerations were sort of, you know, I think you've got to like get a feel for each school as well. But I think the biggest thing though is at the end of the day with law school, it's a vocational training at the end of the day. And I think there's nothing wrong with viewing it as such. I think some people like to view it as an academic vocation. I think there's better ways of going about an academic vocation than going to law school. That's certainly something that I would say is that, you know, if you're interested in like the philosophy of law or what have you, there's better degrees to pursue, and there's other opportunities out there that will scratch that itch basically. Whereas, you know, it's, I think you need to, approach law school with a clear vision in mind and sort of what kind of work you'd like to do after. And you don't always get the work you like after going to law school. So you should have a few options in mind. You should have a plan A, a plan B, a plan C, because, you know, particularly in coronavirus times, like I think a lot of people's career aspirations have been messed up, frankly. You know, they were intending to do something, and that something may no longer be available. And so in that sense, like particularly in times like this, you've got to be flexible, but you've got to have a clear idea as well as the kind of direction you want to take things in.
One thing that I will say is that a lot of people dream about going to Harvard Law.
Mm-hmm.
I mean, from young and old,
mm-hmm.
regardless of background, regardless of country even,
mm-hmm.
a lot of people dream about
mm-hmm.
going to Harvard.
Absolutely.
Or anything really, let alone Harvard Law or Harvard Med School.
Mm-hmm. Mm-hmm.
You had that dream fulfilled.
Mm-hmm.
Take us through that first moment, walking into those halls and through the same places that former U.S. presidents have walked
mm-hmm.
through.
Yeah.
What was it like? How did it feel like?
Yeah, funnily enough, we also have had Canadian not Canadian prime ministers, but Canadian politicians who walked through there. I remember Robert Stanfield actually was the first Canadian editor of the Harvard Law Review. And we've had like politicians in many countries actually walk through there, Asian countries as well, and European countries. And you know, it really is, and you're absolutely right. You know, I met particularly from the Harvard LLM program, people from so many different countries. And you're quite right, from many people from many different countries. You know, and the LLM program was one of the most impressive things about Harvard Law School. You know, was, you know, I think entering there was sort of like the first impression that you have is sort of that it is an incredibly well-resourced Harvard Law School. And I think in that sense, there's few places that could rival the kinds of resources that Harvard Law School has. And just, it has a certain purchase power, a certain what have you, a certain endowment power that even other top law schools can't really come close to matching. And so, you know, from the buildings, from the law library, from, you know, everything about the infrastructure of the institution, you know, it is very clear this is across the board, not just the law school, but the undergrad as well. incredibly well-resourced place. And so that was something that always stuck with me, like whenever I was writing papers or doing research assignments, is that everything was at your fingertips at the heart of and anything from the most obscure sources you could imagine you could get at a Harvard library. That's one of the things that really strikes you when you're there. In terms of, you know, and yeah, you know, in terms of the student body, you know, articulate, you know, well-rounded, you know, and you know, you can tell they're careful to sort of curate, you know, what the student body is like. With the LLM class, you have some incredible people from across the world, really, people who've already made massive differences in their own countries, who, you know, as much people you can learn from as people who are there to learn. And, you know, we had once, I think, we've had Supreme Court judges from African states, you know, who've really been involved in some of the most challenging jurisprudence you could imagine. We've had lawyers, established lawyers from Europe, from Asia, from Latin America, a huge amount from Latin America. And, you know, it really, it's and so really to have that kind of community of people who you can speak to, and also in the JD program as well, you know, people who've had years of work experience, you know, often in the US Capitol and in US finance and US consulting, that sort of network that you can build there, and sort of the you know, the experiences that people can share with you is one of the things that really you have an impression of, basically. And so it's intimidating, certainly, and you know, certainly a lot of people do have imposter syndrome there as well, and what have you, and you know, but I think as well, it's just an incredible opportunity, I think, to really figure out how you fit into that, and to really share with those people, you know, the experiences they've had, and learn from each other as much as learning from the professors. The professors are, you know, again, famous professors, and you know, certainly I found some of them who really were involved in politics and what have you, in ways that I figured were very important. I had a professor who was involved in campaign finance reform in the US, which I think is incredibly important, and he really pioneered ideas in that regard. And so, you know, just I think the level of qualification that people have, you know, I think it really sticks with you.
And that's certainly a factor of not just Harvard Law, but a lot of really good, well-resourced law schools.
Absolutely.
That's such an important element to have. Law is a practical field at the end of the day. So to have all these experiences, and in your case, a lot of very interesting experiences. I mean, it's not just your colleagues who have made a lot of changes in their respective countries. You've also made a lot of change, societal change too, early on with your research in two ways. One way is, well, your research time with Professor Steinitz and your research in particularly with litigation in or at the New York Senate. And the second thing is your publications, especially that book chapter in Designing a Sustainable Financial System, Development Goals and Socio-Ecological Responsibility. Firstly, I want to get to that work with the New York Senate. How did you get involved in that? And did you ever get a chance to present your findings directly at the New York Senate?
Well, I assisted the professor, actually, Professor Steinitz, who gave fantastic testimony to the New York State Senate regarding an issue that certainly is very pressing in the legal field, particularly in the international legal field, particularly in international arbitration, but increasingly in domestic litigation. And also more so, I'd say, in Commonwealth countries, in Canada and the UK. Litigation finance, it plays a bigger role. You're talking about the Burford Capital or Bentham or what have you, basically. Those financiers are already playing a bigger role, I'd say, in Commonwealth litigation than they are necessarily in the US, where there's certain legal doctrines that continue to restrict the role that litigation financiers can play in the US courts. But it is quickly fading, those restrictions. And you know, the New York Senate was coming to realize that you know, there was a need to have a better system of regulation as opposed to simply banning litigation finance. There was a need for a smarter system of regulation that recognize both the benefits and the potential pitfalls of litigation finance. And really, litigation finance is a way, for particularly plaintiffs who have meritorious cases but don't necessarily have the financial wherewithal to pursue those cases, to get various means of financing that are appropriate for their case, to then proceed to take their case to the court system. And certainly, and there's access to justice considerations which litigation finance can help with. There's also fears that litigation finance will influence the way cases are done in ways that would be problematic. That it may lead to traditional fears that litigation finance will lead to over litigiousness. The idea that you're getting paid to create a problem in the court system, and so I think it's a complex issue how you balance those two things, and so that was sort of what we were trying to grapple with is how do you allow for that access to justice benefit for people who have a case already. They're not just trying to create trouble. They have a meritorious case and they can't pay for it, so litigation finance should be there for them. But how do you also ensure that they're not just telling people to go and do a lawsuit, what have you? And I think that, litigation finance is a lot more sophisticated than people think it is. I think that the kinds of behavior that they think is happening is probably not happening in the way that a lot of the traditionalists think it's happening, in my personal opinion. I think a lot of this dislike of litigation finance comes from traditional dislike of lawyering and traditional dislike of the court system. But I think that, to have that traditional dislike of it, I think we've crossed a bridge now where we are a more litigious society anyway. And so the issue is who gets access to that? Is it just the people who have the money who get access to that? Or is it, everybody has access to what is now our dispute resolution mechanism, one of the primary dispute resolution mechanisms in society? And particularly in the international arbitration context as well, you're seeing a huge amount of activity with litigation financing now. And so these companies are growing, they're growing rapidly. There is certainly actually, I think, speculation as well, which I think is somewhat credible that these could continue to grow in light of the coronavirus pandemic, because there's going to be more claims, I think, that people don't have money to bring, but which need legal settlement. And so I think this is absolutely a field that's going to be growing, and I think it's already there in Canada and the UK, and it's coming to the US.
Yeah, this problem has already been here before the pandemic, way before the pandemic. This has been an issue for decades. Before even the most recent global recession in 2009, not counting the pandemic-imposed recession, of course. This has been an international problem, an international domestic problem, to be specific. Every country that has a working legal system that's a fair and just system has this problem. Canada has this problem as well. We have our fair share of access to justice. Australia also has a similar problem with this as well, specifically in regards to Indigenous peoples in Australia, similar here in Canada as well. So there are so many parallels in our legal systems, regardless of our countries, that really bring into perspective a lot of the complexities of not just the systems, but also people's attitudes towards it. I mentioned this on previous episodes in this podcast. There's a need for lawyers. There's certainly a need for lawyers, but the access to justice is such an important factor in terms of it. And the perception of us, we have a duty. We have a duty. We offer a service to our clients, no matter who our clients are. So as lawyers and legal professionals, we must remember that as we're going forward with our work in any capacity, even if we're not practicing law. We must remember that we have a privilege of being trained in this field, and we must not squander that privilege at all.
And we must, I think, make contributions to the field that are increasing that access to justice. And that means, I think, pushing past prejudices that we may have, pushing past, the guild mentality that has sometimes been the case with lawyers. And I think as well, recognizing all the opportunities that do exist now for improvements to access to justice. But also, I think, we do play an important role as well in terms of protecting the public, and this comes back to the earlier conversation we had about certain law schools, which, made certain promises that they couldn't fulfill in terms of improving people's lives and improving access to the legal profession, which they did not fulfill. And, we certainly have a role to not just say anybody who comes up with any kind of idea, get in there and we'll support you kind of thing, because some ideas have unintended consequences and will cause more harm than good and will disillusion people with the whole system. And I think that some of those American law schools that, were doing those things, disillusioning people with the whole system to some extent. And, and so I think we have a role to be responsible gatekeepers. I think to understand what the unintended consequences of things could be, but also not to stand in the way of the progress. Absolutely. I think too often the legal profession as well has used its role as a gatekeeper to therefore stand in the way of innovations that exist, particularly in this day and age, to improve access to justice. Whereas in reality, I think, like I was saying, we've got to find a way to smartly regulate those innovations and manage the downside consequences while still ensuring, absolutely, because there's a huge issue with access to justice. I think, the idea that corporations and the big players have more access to the courts for their disputes because they can fund their disputes more than people who are low on the socioeconomic back, particularly the middle class. And I think that's one thing that we sort of have to discuss as well is, if you're very poor, let's not say there's a very good access for the poor, but there are services that do exist for the poor, in terms of legal aid, in terms of certain pro bono work and what have you, so to speak. But if you're talking, let's say, about a small business owner, a middle-class individual who has a meritorious legal there's often not a lot of competent representation that those people can find at an affordable price. And so I think we've got to speak as well to the extent that, a court system that's not just, that's serving, the broad bulk of society, that everyone has access to and is using in ways that is advantageous to them and that allows for the fair adjudication of their disputes. I think we've lost that a bit in the court system in recent years. If you go back 40, 50 years, there was more accessibility, I think, of the court system, at least for middle class people and what have you, so to speak. And I think now, we have to, I think, find ways of ensuring that there's conduit legal opportunities. Let's give them to small businesses, let's give them to middle class people, let's give them to, all sorts of things. And so, and I think there's ways of doing that, like litigation fines, for instance, or what have you. It's just about smartly regulating that and about ensuring the legal profession is not just trying to gatekeep without really focusing on access to justice.
Exactly. And COVID-19 has actually forced a lot of progress to be made in the way how not only we practice law, but how the system is being run.
Right.
Here in Ottawa, well, I say here in Ottawa, despite the fact that I'm recording this from Mississauga, in Ottawa, I know for a fact that in the Ottawa Citizen that the Ottawa courthouse has been processing bail provisions online now.
Right.
They've been doing that since the COVID-19 pandemic, and many lawyers have been saying that this is a progress point that has been greatly needed for so many years. And I agree too, because having back when I was still at Carleton, we had a course called Criminal Justice System. And one of my assignments was to go to the courthouse, sit in on a court proceeding, and just observe how they process bail, how they process accused individuals, how they process mental health courts, drug treatment courts, so on and so forth. And when I was there, I saw 3 cases where they had to adjourn it. In 2 of those cases, they had to adjourn it for a 3rd time. And I went there in January, so it was in the middle of dead winter, and Ottawa has a particularly bad winter for Ontario standards, Southern Ontario standards. And the reason why they adjourned it was because those people, those accused individuals, I should be more specific, those accused individuals were being driven from a facility in Cornwall on an hour drive on regular, normal, good traffic on clean highways towards Ottawa to be processed for bail. Now, even in the summer, that is ridiculous. Why would you? That's pathetically bad. Why would you use that system at all? Let alone in the middle of winter.
Right. Yeah.
And the thing was, they adjourned it because they couldn't even get the car out. They couldn't even get the truck out. I'm just sitting here thinking, what, seriously?
It's archaic. Yeah, it's unnecessarily archaic. And
exactly.
And that's what I was getting at. Yeah, it's.
I mean, nowadays, literally nowadays, as in this year alone, finally that court has moved on to a system where that person, that accused individual, that person can sit in his or her cell and have his or her bail proceeding processed without any delays. Now adjournments are almost unheard of. There may be a couple, maybe on other procedural factors that I may not know of, but now it's possible to process a lot more in a much more timely fashion, and most importantly, to clear out the backlog. And I'm just thinking, we should have had this change implemented 10 years ago.
Absolutely.
I mean, you go to Norway, they now even process international cases over Skype. There's for our listeners and viewers, if you look online, there's a computer repairman named Louis Rossman who was actually giving his testimony from Manhattan, New York, to a Norway court regarding Apple parts, refurbished Apple parts. And if Norway can do that on a regular basis, why can't Canada do that? Right. So, and I'm just happy.
I guess the fear with stuff like that was always, the idea of people testifying not on the stand is the idea that you couldn't interact with someone on the stand, basically. And, the lawyer would have less of an ability to sort of appropriately, not only seeing their truthfulness in the direct examination, but seeing also appropriately that they could cross-examine the person, and that a jury or the judge or whoever the fact finder is could see their demeanor and sort of like and what have you, and so that's it's an interesting dilemma to me. I think that certainly there's we're seeing a lot of that now because it's necessary that we have virtual testimony, but. I think there's pros and cons to that. I think it's working better than people thought. I would say, in the sense that we have more detailed online platforms now, but certainly we also we have, but certainly we also, I think there's something to be said for the idea of having someone on the stand. And I think also like really discerning what kinds of witnesses maybe that you could have virtually, so that it's not as much of a burden on everyone to do that, but also perhaps discerning as well the kinds of witnesses that maybe you do need on the stand, particularly the types of witnesses for whom there may be questions of credibility and what have you, so to speak, and the fact finder may need to see them in person. And so I particularly have thought about, as long as I did trial advocacy workshop, I've been involved in trial work. And so these are definitely considerations in play. And there's a certain, if you talk to litigators, they often think there's a certain sacrosanct nature to the trial system. And the other thing that we should bear in mind as well with all this is the difference between common and civil systems, and there are innovations in civil law systems which may not be as appropriate in common law systems, and vice versa. And so I think Norway might be a civil law system. And so with that being said, the way in which they cross-examine witnesses and what have you, basically, would be different than in the common law system. And so, that's certainly another factor that's in play. But you're absolutely right. I mean, this pandemic has created the kinds of changes that people would only have dreamt of in a profession that is as traditional as the legal profession, because it's been forced on everyone. And it really has, and I think I think overall it's a very positive thing, as you're saying, because I think that we now have an experimental time that we can look back to and see what worked well, what didn't work well, but we took the opportunity to try things which we've refused to try for a very long time. And now we can see, what's working well, what needs to be tinkered with. But I think that hopefully we'll be coming out of this with a much more sophisticated and modern legal profession.
One other issue that has come up more so than in the past is the issue of sustainability in the legal system. And not just the legal system, but also in the financial system after COVID-19. In your book, you wrote about the incorporation of environmental, social, and governance factors, or ESGs, into the current financial system. Just to briefly summarize for our audience, why are ESGs important for making the current financial system more sustainable? Thanks for watching. If you enjoyed the video, click the like button. If you want to see more, subscribe and click the bell icon so you'll be notified whenever we upload. You can also visit us on our website, thelawschoolshow.com, and you can follow us on our social media. Thank you so much for watching, and we'll see you in the next video.